The Bill of Rights was ratified in 1791. For more than 100 years, Americans had the right to be free from unreasonable search and seizure, but that right existed little more than on paper. In other words, the average American probably couldn't tell you what it meant or even recognize an unreasonable search and seizure, even if it was right in front of them. One of the first cases to begin to define an unreasonable search and seizure was Weeks versus U.S. Weeks versus U.S., which was decided in 1914, first defined the exclusionary rule. You may have heard of this before. The exclusionary rule is defined by case law and states evidence and persons obtained unlawfully by the police will be excluded at trial, or in other words, can't be used by the prosecution as evidence to convict. The case started in Kansas City when a man named Weeks was arrested for using the mail to transport tickets for a lottery, which was against the law. Officers arrived at his house and searched it without a warrant. Now, to us today, that's obviously a huge problem. But at the time, once again, the average American and probably even the police didn't know what an unreasonable search and seizure was. We often rely on case law to interpret and define our constitutional and statutory rights. There just wasn't any meaningful case law to that point yet to give the protection from unreasonable search and seizure any substance. The police themselves possibly didn't realize they were doing anything wrong, or they believed the lack of a warrant to be a minor technicality. During the warrantless search of Weeks's residence, the police seized articles and papers. They left, and later they even returned and searched the house a second time without a warrant, this time seizing more letters. Weeks was eventually convicted of unlawful use of the mail based upon this evidence collected without a warrant. The Supreme Court of the United States reversed his conviction and held evidence that was obtained unlawfully, in this case without a warrant, could not be used. This exclusionary rule, as it came to be known, only applied to federal law enforcement, however, and the exclusionary rule would not be applied to local, county, and state law enforcement for more than 40 years until the 1961 case of Mapp versus Ohio.